All right, good morning and good afternoon, everybody. Thank you for joining us here today for another installment in our HSB Employment Law webinar series. We are back again talking about COVID-19 and the vaccine mandate, which I'm sure is on everybody's mind currently about what to do. I've got my colleague Chris Gant Sorensen here with me, and hopefully between the two of us, we can put our heads together and help everybody at least figure out a game plan for your own organization as to the next steps here, because I know that there's a lot of uncertainty. But before we dive in too much into the substance, for those of you who are joining us for the first time, a couple of reminders for you. Our employment law team here at HSB runs a blog, scemployersblog.com, and that's a really good resource for information in between the times that we do these webinars. We try to push out relevant information to you through that through that blog. So please consider signing up for that if you have not done so. Please utilize the Q&A chat in the Zoom platform. While I'm talking, Chris and our marketing folks will try to monitor that, and vice versa when Chris is talking. And we may address some of those directly in the chat. We may stop and talk about them if they're right on topic to what we're discussing, or we may save some of them until the end of the webinar. Just in case we hit on them as we go through. So we do have some good information in the slides today, and those are going to be shared with you after the event. So no worries there. And that we've submitted the course for relevant credits, and a legal disclaimer, of course, there for you about the information that we're being provided is not sort of directed to any of you specifically as to what to do, but is more general information for you in helping determine what course of action you need to take. So I'm going to give just at the top here a sort of overview. I mean, I think a lot of the questions we're going to get are related to what's the current status of this what we call the ETS, which is Emergency Temporary Standard. We may refer to it as ETS. We may just say the rule. I think everybody knows what we're talking about here, OSHA's private vaccine mandate. And we're going to talk a little bit about those specific nuts and bolts of the ETS for those of you who are starting to roll out your policies. And we're going to dig a little bit into disability and religious accommodations. I know both of us have walked clients through some of these. Undoubtedly, you will get some of them once you roll out this policy if you haven't already. And then we're going to talk a little bit about the guidance for federal contractors, given that many on this call are not federal contractors. We won't spend a ton of time on that, but Chris and I have advised some clients on that. And if you have sort of more detailed questions about the federal contractor guidance, we're happy to talk with you about that. So like I said, just here at the top, I'm going to give you a little bit of current legal status, and this is changing all the time. In fact, we just received word, I guess yesterday, that on Friday we got sort of a new update. As you know, lawsuits all over the country have been filed challenging the legality of this mandate, of this ETS. And without getting too much inside baseball, the argument has basically been that basically the OSHA doesn't have constitutional jurisdiction to issue a rule like this in the way that they're doing it sort of on an emergency basis. That the Congressional Act in 1970 that created OSHA gave them the power to issue these sort of emergency rules, but only in sort of limited circumstances where there was a grave, danger in the workplace. And those that have filed lawsuits challenging that have asserted, well, this isn't really one of those situations. That's not really what Congress had intended when they passed that law. We got the Fifth Circuit Court of Appeals has been the first, and their lawsuits all over, and they go straight to the Federal Court of Appeals. And the Fifth Circuit Court of Appeals has gone ahead and issued an injunction preventing the rule from going into effect. Pending a more full review of the case. They issued that sort of immediately. They've taken that under consideration, and as of Friday, issued an order saying that they're making that injunction or that stay permanent. And there's a lot of questions about that order. The first question is sort of so the Fifth Circuit Court of Appeals encompasses states of Texas, Louisiana, Mississippi, is a certain geographical area, and there's a question as to whether that order by the court applies to businesses in other states. So if you're a business operating in South Carolina, you've only got employees in South Carolina, does the Fifth Circuit's order apply to you? Chris and I were talking a little bit about this before we jumped on, and the order is not explicitly clear on that. It seems to be that they are trying to, that they have ordered, in the last couple of lines of the order, they say that that they're ordering OSHA not to implement this or not mandate it. And so it seems to be trying to take nationwide effect, essentially. We sort of don't know yet is the best answer. What is going to happen is, since there are cases filed in every circuit court of appeals, what happens is there's sort of a lottery system, and the federal court system chooses one circuit to hear the case. We're expecting that to happen today. That may be the Fifth Circuit, that may be another circuit, but they consolidate all the cases into one so that there's not sort of different orders from different courts. And people are expecting that to happen today. I'm not sure if it will. And then we're going to have another court decision probably, which is going to either continue the injunction preventing this from going into effect, or it is going to lift the stay and allow it to go into effect. And most things that I read seem to think that ultimately this is going to wind up before the U.S. Supreme Court. And so it's all a little bit, from a strictly legal perspective, a little bit up in the air. And what I think makes this challenging for you all as employers is that, this ETS has some pretty tight deadlines in it, which we'll talk about, December 6th and January 4th for compliance. And so it puts you in a little bit of a tough position as to rolling out and beginning to implement this policy. But the risk in sort of doing nothing and waiting to see how the legal process takes place is that you may be a little bit behind the 8 ball as far as rolling out this policy and getting people vaccinated and things like that. So we'll dig into a little bit deeper into sort of, how we think you should plan based on this. But I just want to give that overview. There's also a bill or bills being pre-filed in our state legislature to prohibit vaccine mandates. And Texas has already passed one of these laws. And if the OSHA rule does go into effect, you would have, even if you're in South Carolina, you'd have to comply with OSHA. The OSHA rule would sort of trump, so to speak, the state rule under the federal system. And so that's important to keep in mind as well. So that's just a sort of snapshot of where we are. And Chris, I'll bounce it over to you, and happy to sort of hear your thoughts on that as well if I've missed anything.
No, I don't think you have, Perry. Definitely agree with you that any state law that South Carolina passes is going to have to be second or unenforceable if it conflicts with OSHA's law. And that's going to be true, not just in this situation, but generally. In regards to the Fifth Circuit, Perry and I have been flummoxed in a professional way about the basis that the Fifth Circuit asserts a national stay. Maybe one of the reasons is so that it can get it escalated to the Supreme Court. He looked through it thoroughly, and I looked through it, not as thoroughly, but quickly. And we don't see that it's outlined the jurisdiction, its basis for taking jurisdiction over the nation when the Fifth Circuit only has jurisdiction of the states that are in it. Pierre, we've gotten one good question. Hey, we're in the Fourth Circuit. Does this apply to us? Great question. We are in the Fourth Circuit. And only the Fourth Circuit Court of Appeals is mandatory authority for us to follow. The next level would be Supreme Court. So the Fifth Circuit is not a court that we have a mandatory obligation to follow. It's a federal ruling on a federal regulation, and therefore it could be persuasive, i.e. informative, but it's not something we're required to follow. And I would submit the Fifth Circuit does not have the jurisdiction to issue any stay that would be applicable to the Fourth Circuit. I think the broader issue is what Perry pointed to. There are so many suits that have been filed that this is going to have to be dealt with, and it could be dealt with by the Supreme Court quickly as well. But it's going to have to be dealt with on the federal appellate level and then popped up the Supreme Court. There's a lot of things that have to happen for that to happen quickly, but it does seem like it's going to be necessary. Don't you think, Perry?
Yeah, I think so. I think, and we can dive into this. I think there's steps that make sense for you to go ahead and take, by the December 6th deadline. And there are ways you can get your ducks in a row while sort of waiting and seeing a little bit. And we'll dive into that.
So I think Perry's absolutely right. And he's keeping me on track. The other part of that question is, should we prepare? The answer to that is yes. And there's actually, other than issuing a policy by December 6th, there's not a lot you have to do before then. And so, like Perry said, we will dive into that. We would encourage you to proceed to prepare. I will tell you, I remember mindful of the Affordable Care Act that was passed in 2010. And it wasn't until 2012 that a lot of folks started listening because they thought that Romney was going to get elected and kick it out. Learn from that because they were behind at that point compared to the folks who had been preparing all along. It was a lot to prepare for. This is less so, but until told otherwise, you need to plan on complying. So here's some myths, things that we're hearing. Governor McMaster's ordered state agencies don't have to mandate the COVID-19 vaccine, and that ETS is not going to apply in South Carolina. Governor McMaster does not have the authority to trump what OSHA has said must be followed in OSHA's regulation. So that's a myth, and he does not have the authority to say we won't follow OSHA's regulation. Just like you have to follow OSHA's other regulations, that's also true here. If it's put, opposite of what the governor wants. President Biden can't make private employers mandate a vaccine through an executive order. He did not. President Biden did not issue an executive order that's applicable to private employers. President Biden has the authority to require federal employees and federal contractors to be vaccinated. And that is where his authority ends on this point. President Biden can direct OSHA as an administrative agency under the executive branch of the government to issue temporary standards, emergency temporary standards. And this won't be the first one that OSHA has issued in regards to COVID. They issued a healthcare emergency temporary standard in June. So him directing his agency to do something does not mean that the agency isn't acting within its authority, nor does it mean that it's President Biden directing it through the agency. The agency was already issuing a standard earlier, as we indicated, and has been issuing standards and guidances on COVID compliance since the pandemic onset. OSHA cannot pass an emergency regulation and make private employers comply. OSHA absolutely has the authority to do that. OSHA exceeds its authority if it steps outside of the enabling clause in the law that Congress passed to enact OSHA. If it is determined that OSHA, in issuing this or any standard or any regulation, exceeds their authority as expressed in the enabling statute, then this statement would be true. But if OSHA has acted within its directives in the enabling statute of the act that created OSHA, then OSHA is absolutely within its right. And under the Administrative Procedures Act, employers, businesses have to follow this. Next slide. Other questions being asked. Can OSHA require private employers to mandate vaccines or test their employees every 7 days? The answer to that is yes, they absolutely can, just like they can require employers to do other things. Can an employer require the employees entering the workplace to be fully vaccinated? Yes. And I think you've been seeing that already, particularly with healthcare facilities where they are issuing mandatory vaccination policies without the alternative testing method. An employer does not even have to be a healthcare provider to issue a mandatory vaccination policy. They're absolutely within their rights. The EEOC has specifically said that. And you'll see we've put a lot of resources at the end of this PowerPoint that you can jump on, to see these things for yourself. And that's squarely from the EEOC, that an employer has the right to do that long before this ETS was even issued. Is an employer allowed to ask employees if they're vaccinated or not? Yes. The EEOC has specifically said that does not violate the American with Disabilities Act. An employer is required to keep that information confidential pursuant to the American with Disabilities Act confidentiality rules. Only 3 instances in which an employer can share information about whether an employee has been vaccinated or not. And it's not just the employer holistically, it's a specific division of the employer, so human resources and maybe a few people in management, but otherwise it should be kept confidential. Our company can avoid complying by reshuffling our employees so that none of our offices have more than 100 employees. If you have 100 part-time or full-time employees on your payroll roster, you have to comply. And another thing to think about, which I think is a sleeper issue, not to forget, if you've got a bunch of temporary employees and you're close to the threshold of 100, on your payroll, but you've got temporary staffing employees, and they are employees who might be seen as your joint employer under the eyes of the law. Namely, they're working there more than 90 days. And even if it's less than 90 days, they're actually performing the business that other employees that you have that work directly for the company perform, as opposed to a type of business or a project that you don't do as part of your business. Or if you treat them like employees. So there's a lot of factors that go into whether or not an employer is a joint employer. And just because an employee is there that works for a staffing agency and they're performing duties for the company does not mean that you don't have to count them. You need to probably think about it from the joint employer standpoint. And that's some of the things we've been talking about with clients in regards to this ETS. The last one is, my organization can wait until the stay is lifted to begin making plans to comply with the ETS. And as you've heard Perry say, and I'll echo, please don't do that. You've got a requirement by December 6th to issue a policy. And really, that's all you've got to do right now. And you want to go ahead and meet that. We've got policies that we're working on for clients and a whole package. And so, Perry will talk about that, but we're glad to help anyone. Go ahead and put what you need to in place to comply so you're not behind the 8 ball. And then keep your ear to the ground and let's see what happens next.
All right. So that's a little bit of information on where we stand and what some of the common questions about the enforceability and the application of it are. I'm going to jump in now to sort of the nuts and bolts of the rule itself and what you're required to do. So already a question in the chat about federal contractors. This emergency temporary standard it does not apply to businesses with less than 100 employees. It does not apply to federal contractors and subcontractors, and it does not apply to companies that are subject to CMS requirements, so who receive Medicare and Medicaid reimbursement. So your healthcare type organizations that do that. The federal contractors and healthcare employers have their own rule that are really more strict than this rule. If you are under 100 employees, you don't have any mandate at all. Not to say that a company that you contract with, may not require it. I've seen that some or something else, but no mandate from OSHA or from the government to do that. I think what I would say on the 100 employee threshold, we do get a lot of questions about what employees to count. And, I would tell you that if you're sort of right on that line, or you think you are, and that's going to make the decision for you whether or not you comply. I would encourage you to reach out to us or other legal counsel to kind of discuss that, because it's not just limited to one site. It would include employees at other sites. Um, and it would include, generally speaking, employees of affiliated entities. And so that's something to keep in mind. Another question we've gotten is about remote workers. And remote workers are included for purposes of the 100 employee threshold. But they are not included for some of vaccine requirements, which will. So that's sort of who the rule applies to at the company level. There are certain groups of employees who are exempt from the vaccination and testing requirements in the rule. And those are, even if you're subject to the rule, these employees might be exempt. Those people that work exclusively from home and are not interacting, coming into the office at all, interacting with customers or anything like that. Those who work exclusively outdoors, and that again, that can't be coming in the morning and checking in an office, but they are working exclusively outdoors. Or if it's a workplace where there's no coworkers or customers present. So if you do report to a workplace, but you're the only person there, you would not be subject to the vaccination or testing requirements. So there are basically, they're subject to the rule. There are basically two options for you to decide on what your company policy is going to be. One option is we're going to mandate that everybody receive the vaccine, and going to give any option for people to remain unvaccinated but to submit to testing. That's one route. Route number two is we're going to mandate vaccinations, but we're going to allow employees to remain unvaccinated if they are willing to submit to the testing and face covering policy requirements. And we'll dig into maybe how to choose the two of those if you're undecided. As Chris mentioned at the top, you do have to determine your vaccination status of every employee, and there's record keeping requirements of employee vaccination status and employee testing. And so obviously you're able to ask employees if they have been vaccinated. There's no problems there as long as you comply with how to do that. And then there are requirements in the ETS for paid time to receive the vaccine and to recover from side effects of the vaccine. It's sort of an open question as to who pays for testing, which we'll discuss. There's face covering requirements if you choose the policy that allows for testing, or if you grant accommodations to those vaccination requirements. And I'll go ahead and mention for the accommodation piece that even if you choose mandatory vaccination only, so you're not going to give employees the option to remain unvaccinated and test, you still do have to consider accommodations to your mandatory vaccination policy, religious and disability cases, and we'll discuss that in more depth later. And I apologize. I've been informed in the chat that I'm having some issues with internet connectivity and maybe coming in and out. So if I do come in and out, Chris, you can jump in since you're up to speed as well, obviously. So one of the things that we've made reference to now is the fact that there's really two key deadlines. One is December 6th, which is something that you have on your radar, I think, regardless of the legal status. And that's going ahead and establishing a written policy and notifying employees of that policy. I think that most of our clients have probably already been in communication with their workforce at this point in some manner. An email just saying, hey, we want to keep everybody informed. This was passed. This is what we're thinking about doing, or this is what we plan to do. And that might be a good idea to consider doing if you haven't had any communications with your employees on that point. But by December 6th, to go ahead and implement one of the two policies, and you can see on the screen there what your choices are, either mandatory vaccine or the vaccine testing and face covering policy. I think one thing I would point out and choosing between the two of those is it really is going to depend on your workforce. I mean, I think from a big picture perspective, most of the clients that are choosing option 2, which is the testing option, are ones where they have a significant portion of their workforce that they already know concerns about. Am I going to have employees leave? Am I going to have a real staffing issue if I just, if I don't allow them to remain unvaccinated? So that's one. The other thing
I'm going to go ahead and, there he goes. There you
go. Okay. One thing I was going to say is that we don't really have great clarity from the Department of Labor on whether they're going to require employers to foot the bill for the testing and off for testing. And so that's something you may want to keep in mind if you're considering an option. So that's sort of the December 6th line. And the January 4th deadline is what applies to the actual rollout of the vaccination and or testing policy. So by January 4th, if employees are not vaccinated, then they have to submit to weekly testing. Or if you've chosen a mandatory vaccine only option and you've got employees who are not, completely unwilling to go get the vaccine, you have to make choices at that point in time as to how to handle their employment moving forward. So fully vaccinated means receiving all primary vaccination doses, and that's 2 for Pfizer, Moderna, or 1 for the J&J. And we've had a lot of questions about the vaccinations, and Pfizer, Moderna, or J&J all meet that requirement. At this point in time, I'm not aware, and Chris, you may know this better than me, I'm not aware that there'd be any requirement for boosters at this point in time. I've had a couple of questions about that. Even if you're, theoretically eligible to receive a booster, or doctors recommended it or something like that. It's not a requirement that you have to make for your employees. So regardless of the policy you choose, there are record keeping requirements in here. You have to determine the vaccination status of each employee and retain those as medical records. And there are some sort of sample instructions for a policy that are pasted into the slideshow there that I think would work well. So you are going to have to require employees to submit proof of vaccination that indicates full vaccination. And, I don't think it requires you to be, sort of a forensic expert on people that may be submitting bogus vaccination cards, but I do think you've got an obligation to look at the vaccination card and see whether or not on its face it appears valid. Obviously, if you've got specific concerns, if you think from the face of the vaccination card or something like that, that it might be forged or fraudulent, I'd urge you to sort of consult with counsel on how to, approach dealing with that. And the same goes for test results as well when we talk about test results. So for employees that have not been vaccinated, submitting a statement why you're not vaccinated. So, that's one question I've been asking clients. They say, well, so-and-so is not vaccinated. What do we need to do about them? My first question is always, well, why are they not vaccinated? And they say, well, we can't ask that. You can ask why someone is not vaccinated. You don't have to delve into their whole medical history, but you are going to need to know whether it's something that they're not vaccinated because of a sincerely held religious belief or a disability / medical condition, or are they simply objecting to the vaccine on personal or political grounds. That's going to make a difference. So you can require a statement in writing from them to that effect. Chris, I might let you pick up here since I've had a couple of internet issues, and it might be a good time.
All right. So acceptable proof of vaccination, the standard actually outlines what is acceptable proof. And obviously the most common one that employers will see are the COVID-19 vaccination record cards. And some of you may already be, doing these types of things and requiring these. These are all of the examples that you can accept in the rule. So record of immunization, copy of medical records documenting the vaccination, copy of the immunization records from a public health state or tribal immunization information system. So, you think about in our state, that would be DHEC for the public health. Or official documentation that contains the type of vaccine, administered date, name of the professional, and the clinic site. If all else fails and an employee can't provide that, then the employee can do a signed attestation with certain information. Now, this is interesting, and we'll hit on this a little bit later, but obviously it begs the question of, well, those employees who don't intend to get vaccinated don't want to. This is giving them a way to write they did it and they're attesting it. And that's true. I think it's interesting. But there are some teeth in the OSHA regulation applicable to employees for criminal liability if they've provided false records. Ideally, I would think you would want one of the 5 first bullet points on this list, and even better maybe the COVID-19 vaccination record card. But the rule says you can take any of these. So this is one that I've had particular trouble with, which Perry will echo because we talked to a client about this early, is paid time for vaccination. But it is true that the OSHA regulation does require employers in complying with this government regulation to pay for employee time to receive the vaccination up to 4 hours. Not has to be 4 hours, but up to 4 hours. And this is time enough, reasonable time for them to travel to the vaccination vaccination site, do what they need to do, the documentations they need to do, and get the vaccination and come back. That's all this applies to, is getting the vaccination. You'll need to put in your policy that an employee is permitted to choose between doing it during work hours or doing it after work hours, which I'll admit I also didn't love, because of course we all know they'll all choose within work hours. And so I didn't like that, but you have to put it in there that they choose. There is nothing to say, though, that someone who's already gotten vaccinated or someone who chooses to do it after hours has to be paid. So that's an interesting thing in the rule, but it has to be followed. Unlike the FFCRA, where we saw employers being able to take tax credits for government mandated pay that otherwise the employer was not having to pay, we don't see anything like that in the ETS. I hope that will come out, something to that effect. And if it does, just keep your eye on the blog. Perry and I and the other folks on the employment team will be writing about it and alerting you as soon as we know. But right now, there's nothing like that. Paid time for recovery. Now, while you cannot require an employee to use their accrued paid time, whether it be sick leave, vacation leave, PTO, however you do it. You cannot require them to use it to go get the vaccination. You can require them in your policy to use any accrued paid leave that they have if they need to be out to recover from getting the vaccination. An employee is required to use it in your policy. That's absolutely fine. But if they run out of it before the expiration of 2 days, then the employer will have to cover the cost up to 2 days. An employer does not have to cover the cost of the paid time out to recover from the symptoms after the 2 days, pursuant to the standard. So, in that situation, obviously you're going to want to verify too that they've needed to be out. You're going to have to decide how much documentation you want to verify that they needed to be out to recover. It might be difficult to refute, but I can remember last summer when all of this came down, 2020 summer, and how difficult it was for some of you to keep your workspaces staffed. And so be thinking in terms of, are there any protections you can put into place so that everybody's just not running off and taking 2 days? When I read this, I thought this is going to be a hard one to deal with. And maybe some employers from a logistics standpoint will just, deal with the 2 day piece. But it is a problem. Next slide. Testing requirements. Nothing in the ETS requires an employer to pay for testing. So don't undertake to do it. If you undertake to do it, then you are required, either in your policy or in your practice. The testing requirement is every 7 days. And there's nothing that requires an employer to permit an employee to do this during work either. So it can be after hours, after work, and it does not have to be paid, and you don't have to cover the cost of the test. I would always have an exception in your policy for some employee who's not able to comply with this provision outside of work hours, but I would want you to have them contact HR so that you can consider what the issue is. And there's going to be extenuating circumstances. I can envision some of them not being able to do this. They may need to pick up children. They may have other jobs. But I think just requiring in the policy, that they can choose. You're not required to do that in the regulation, and I would encourage you to follow the regulation here and grant exceptions where you need to on a case-by-case basis. Another thing too is remember that if you have a mandatory vaccination policy, this also is something you've got to worry about if people have exemptions to complying with the mandatory vaccination that are legally recognized, which we'll talk about later, but those are the disabilities or religion exemptions, or if a doctor has indicated that the vaccination is medically contraindicated or needs to occur, they need to wait for a period of time before they have it. In those instances, you are still going to have to comply with this every 7 day testing requirement. So, testing requirements and recordation. You've got to pick someone that's the point person, obviously put in a logistic process for this and outline that in your policy. And you've got to keep records of the test results. And just like with anything else that's got medical information on it about an employee, it's got to be kept confidential and separate files. You could actually have the ETS compliance file. It's got to be separate, lock and key, and you can also put what you want to in the employee's medical file, but that also has to be separate from the actual medical record, actual personnel file, which you all already know. If an employee refuses to provide the test, the example of the test, you have to have them leave. They can't stay at work. And you need to come up with in your policy how many days you're going to give them to return with a test before you have to take other actions. This isn't a situation where, giving someone a written warning or a verbal counseling is going to help you. You're going to actually need to remove them. And if they ultimately don't comply within the deadline that you've outlined and they don't have an extenuating circumstance for it, you're going to have to let them go. And we spent some time talking about what does that look like, and probably 5 days, depending on the vehicle that the person is using to get tested. 5 days seems reasonable, but always with any deadline that you have, when an employee comes to you and they've got an extenuating circumstance that did not permit them to comply within 5 days, of course, be understanding and give them additional time. This doesn't mean you let them come back into the workplace though. Next slide. All right, face coverings. The ETS actually does outline some rules about face coverings, and we're recommending that you drop those in your policy. It's the same old rules you've seen: got to be covering your nose, got to be covering your mouth, got to be secured. Employees who are unvaccinated are required under the ETS to wear a face covering when they're indoors and when occupying a vehicle with another person for purposes of work. The only exceptions are when, and I think I'm jumping ahead, so we'll go ahead and jump ahead. But if someone has an exception to the mandatory vaccination policy, and they also want to act like or tell you that they have an exception to complying with the testing requirement or the face covering requirement, you're going to need new medical verification for those requested accommodations. Okay, so that's important to remember, that if someone's asked for an accommodation for compliance with a mandatory vaccination policy, that doesn't mean that exempts them from having to comply with the 7-day testing rule and the vaccination, and the testing rule and the masking. So the face covering requirements, the only exception is if someone's eating, or if they're in a space, an office like mine here that has a door that's closed and has walls from floor to ceiling. The other example, or the other exception, would be if they're engaging in such hazardous work that having to wear a mask at the time would be considered more dangerous than contracting COVID. And the best example I can think about that is a fire client that we have, where when they're coming off of a fire, they've had their respirators on, they've got to pull that off and catch their breaths, and requiring them to wear a mask because they're around the other fire persons or they've gotten back in the fire truck. It's far worse what's going on with them about needing to catch their breath than us worried about them getting COVID. So think in terms of that. Next slide. All right, notification and removal. So someone tells you that they have gotten a positive diagnosis for COVID, a test positive, or they're sick with COVID. You've got to remove them from the workplace. This is not new. You're used to that. And they cannot come back until they either provide a negative test. I would not say either. They provide a negative test and you comply with South Carolina DHEC's guidance on return to work. And so at the end of the presentation, we've linked that. All of you have been used to using DHEC's quarantine and isolation rules, and you just continue doing that here. Even if an employee receives a recommendation to return to work from a licensed healthcare provider, I think that could give you an exception to the mandatory 10 days for illness under DHEC, but you would want it dated and signed, and that could be a case-by-case exception. Next slide. ETS requirements. So you've got to inform the employees. Well, that's what we're going to do with our policy. You've got to tell them, what the requirements are of the ETS, and you've got to link the fact sheet, the CDC link fact sheet. And then these provisions that we have cited below, what they essentially mean is that you've got to tell the employees two things in this policy: that an employer cannot discriminate, harass, or retaliate against an employee for reporting an illness or an injury in the workplace. And you also have to tell them that any employee who falsifies information in compliance with this policy could be subject to criminal charges. So that's what the ETS requires you drop in the policy. Remember your reporting requirements, those have not changed. In a situation where someone has a death from COVID that they think is work-related, it has to be reported to OSHA within 8 hours of the employer learning of it, and a hospitalization within 24 hours of the employer learning from it. Availability of records. An employer has to make an employee's own individual vaccination record available to the employee, and then they have to be able to tell the employee the aggregate number of fully vaccinated employees compared to the total number of employees in the workplace. Not anybody's specific name, but just 60% of our employees out of 100%. 72 out of 102 are vaccinated. That if the employee wants that information, an employer has to share it. Next slide. Timeline, we've been talking about that, the testing requirements. So you've got to be ready to start reviewing these tests as they come in on January 4 or after. And then all other requirements, the implementing the policy, December 6. Fines for noncompliance for employers. Serious violation is $13K, approximately per violation. We've been getting those requests. Is it $14,000 and it's only annual? No, it's $13K per violation. That's going to be per individual employee that this is violated for. And willful or repeated violations up to $136,000. These are the specific fines that are outlined in OSHA's general statute. Next slide. All right, so disability accommodations, I'm going to hit those from an ADA standpoint. If an employee comes and says, let's start over with, if you've got a mandatory vaccination policy and you're not doing the either or policy, you need to be more concerned about these exemptions. If you are doing an either or policy and an employee comes to you and says, I can't get a mandatory vaccination because of fill in the blank, disability, religion, what have you, you've got an either or policy. You can say, all right, then that means you're going to be complying with the testing provision. Right? So you can just slide right on past that. But let's say you're choosing to implement or have already implemented a mandatory vaccination policy. The steps that you can follow, according to the EEOC, are as follows. You got to look at it on a case-by-case basis. Part of that's going to be analyzing what the employee's job is, right? So mandatory vaccination for a healthcare provider that works directly with people who are vulnerable or ill would be harder to do. Safety standards that have to be met. People are all working closely together and it's going to compromise the safety of the employee or the safety of the others around them, might be harder to do. So evaluate, is this a situation where it's an essential function of the job that this person has to be vaccinated in order to provide the services that we provide? Next slide. Another inquiry is that an employer has to make is it going to be a direct threat if this employee is not vaccinated? And direct threat is a very specific standard. It means a direct threat to the health or safety of the employee or others in the workplace. And answering that question is not enough. It has to be significant risk of substantial harm, and there's certain things you have to do to document it. Ideally, I'm going to want you to verify from the employee's health provider the conditions, limitations, and restrictions that an employee has that you can use as your basis for a direct threat, because employers are not doctors. So if you perceive it's a direct threat, talk to the employee. And this is the one instance where you can bring up an issue with an employee about a medical concern that you have or a health concern that you have. In this situation, they'll be coming to you saying, I can't do the vaccination. They're asking you for an accommodation. And you are able to go into this analysis through that vehicle as well. But after you've determined, even if it is a direct threat, you have to look at what accommodation can offer. So if someone who you have decided is in a job classification that has to be vaccinated it's an essential function of the job, in order for them to perform their duties, and they're asking you for an accommodation, and you believe it is a direct threat, then you've still got to analyze, can I give them some other accommodations? Next slide. So these are the 4 factors that an employer looks at when they perform an individualized assessment of an employee's present ability to safely perform the essential functions of their job if they're wanting an exception from the vaccination policy. The duration of risk. So what number of employees are already vaccinated in the workplace? And how often is this employee in contact with the other employees? What's the work environment like? Is it outside or inside? What's the ventilation? What's the space available for distancing, particularly for that employee? Example would be if they're in a cubicle or an office that has floor to ceiling walls and the door can shut. What's the likelihood that potential harm will occur or the imminence of the potential harm? And so I would say to you, you're going to want to document the factors that you've considered complying with these requirements in making your determination. Next slide. Accommodation request. Your policy should let the employee know that it's their responsibility to ask you for an accommodation. Then it's important that you train your managers. The policy should say bring the accommodation request to HR, but it's also important that you train your managers on how to recognize accommodation requests, and that's going to be true of any sort of accommodation request. Flexible interactive process is the EOC's word, and what it essentially means is you thinking about, all right, granting the accommodation, is it going to, be a problem? Do I need to get medical documentation? What are the accommodations that we can do? You may, through that process, decide that you need to document the need for the accommodation. My recommendation is typically that you do this for every employee so that you're not picking and choosing who you do it from. There may be some exceptions where the accommodation need is obvious, or if they've already provided documentation of the situation, or if they happen to also be filing other claims, other medical claims and such, disability claims, those sorts of things where you're already on notice of it. Next slide. When you require an employee to provide documentation, you're not having any communication directly with the provider. You're telling the employee to have the communication and let you know with a written note, no verbal, what sort of restrictions this employee has, how long they'll last, and, any sort of temporary or permanent concerns. And then that's the documentation that you look at before you analyze whether or not you can grant the accommodation. Next slide. Undue hardship is your only exception to granting an accommodation. And the most important thing here is that you've got to make sure it's limited to the specific duties of this employee. So is there a way to allow this employee to have this accommodation from the mandatory vaccination policy and still perform the essential functions of their job? And that's going to include requiring or analyzing, are there ways to, parse their duties? You don't want to overload. It is overloading other employees and overtaxing them is going to be an undue hardship. But if there's a way to do it that's not overtaxing other employees or a reshuffling of things in order to comply with this request, then you have to think about it. You want to always be able to also explain why this employee can't mask, that's not going to be sufficient. It was sufficient from 2019 until very recently. So you're going to want to be able to articulate why that's the case. And it's okay. It can be changed now because we have these vaccinations and because we have ways to protect our vulnerable populations where these employees work. But you are going to need to be able to articulate a tangible reason. And then the EAC specifically says if you've done all this and you still believe you cannot accommodate this employee on the work site, you have to consider, is telework an option? And if it's not, then you can consider as a last resort reassignment. Next slide. Religious accommodations, kicking it back to Perry.
Thanks, Chris. And I know we're running here pretty close to time, but we are pretty close to being done. So just get your questions in the Q&A and chat. If there are other questions you have, I think answered most of them as we go along. Stephanie did make the comment in the chat that the accommodations have been the most difficult thing to work with. And I think that's probably true for a lot of organizations. As Chris said, I mean, one good thing about sort of doing this on the front end and figuring out, okay, how many vaccinated employees do we have? And of those who are unvaccinated, how many are submitting requests? If you've got 20% of your workforce who's going to be submitting these requests for accommodations, that may tip the scales into saying, okay, we're just going to do a testing option so that all those employees would just fit into that bucket and we don't have to get into the, real specifics of whether or not to grant these accommodations and all of that kind of stuff. That's just one idea. Because I agree. I mean, we've worked with clients on them and they're difficult. I mean, I've seen legitimate requests. I've seen completely bogus requests. I've seen ones that are a little bit more difficult to figure out. I mean, what do you do with a doctor's note for a pregnant worker who says, the doctor said I recommended them to not get the vaccine, but, the American College of Obstetrics and Gynecology says they recommend the vaccine to pregnant patients. So, what do you do in cases like that? And the religious one is quite difficult as well. Most of the ones that we've seen from the religious side, say something along the lines of the fact that apparently in the creation of the vaccine, in the research, there was stem cells, and it's people saying that their religion is against abortion, and that is the reason that their sincerely held religious belief conflicts with the vaccine because of that, because of the use of that in the research. And that's not the only thing we've seen, but we've seen things like that. And that can be a little bit complicated. And I would encourage you, when you get those complicated ones, to reach out to legal counsel about it, because handling them can be tricky. I will say on the religious accommodation side, the EEOC has published a list of questions that you can ask if you get one. They are very helpful. I've got them here. Anybody can reach out to me and I'll send them to you, or you can find it through the EEOC website. But they're questions like, please describe whether as an adult you have received any vaccines against other diseases. Questions like that you maybe think I wouldn't normally be allowed to ask. You can dig into some of those things if you've got reason to question the validity of the sincerely held belief. I've heard other lawyers say that they're sort of advising their clients to take them at face value. And I slightly disagree with that. I mean, I would analyze them pretty carefully and sort of think about whether it's a legitimate request. The EEOC does say that you should assume that a request for religious accommodation is based on sincerely held beliefs, that the person who's submitting the request has those beliefs. But I still, they've published those questions, so I still think that you can dig into them a little bit further. But again, this might be something that tips the scales in deciding which policy it is you want. So there's some of the things that you are allowed to ask if you get a religious accommodation request. The EEOC states is largely a matter of credibility, and that I mean, that's just not very helpful. I mean, how are you going to decide how credible it is? I mean, that's just very tough. And I mean, do you consider other factors as to previous history with the employee, with other issues that they've had, those types of things. And so again, very, very tricky with the accommodations. So you'll have these slides to look through those, but you can go ahead and go to the next slide since we're about out of time. I will say there's a couple important things here to point out. There's a very tough line from, Title VII does not protect sort of these sort of political type of views, but sometimes there's a fine line between that and sort of non-traditional religious beliefs. So if somebody submits a request and says that, it's some strange that you have never heard of, you can't dismiss it because it's not the, Presbyterian Church USA or whatever. You do have to take them seriously, even if it's not into an established religion. Now, if they say their established religion is Trump 2024, then that's getting into the political and the personal preferences and that type of thing. That's when, it can veer into that, but it is quite a fine line there. So just take that into consideration. And de minimis undue hardship, the standard for undue hardship is actually a little bit different when it comes to religious accommodations. So basically, if granting the accommodation would result in more than a minimal cost to accommodate the employee, that would be considered a hardship under the religious standard. So it is a little bit lighter, although I would sort of be careful with that. I mean, I think the problem with undue hardship, and Chris can weigh in on this, is that, now that you've got this sort of testing option that's sort of granted, is it, I mean, how reasonable of a case is it to make out that, providing a testing option is an undue hardship? If the Department of Labor comes out and says that employers have to pay for all of the testing, is that enough to say that that's an undue hardship on the organization? Particularly for religious accommodations where the standard is de minimis. And so, those are things to keep in mind. And I know we're right at 1:00, so I do want to, Brittany, you can flip through to the last slide, and we've got resources here on federal contractors. I mentioned that at the top, and if you do fall within that category, or if you fall within the category of being subject to the Centers for Medicare and Medicaid Services, CMS's rule for healthcare providers, slightly different, stricter rules for those. So I'd encourage you to reach out to us to talk about the requirements of those rules. And as Chris has made reference to several times, we've been working pretty hard internally, talking through this with clients, talking through the messaging to employees. We've helped companies, draft, sort of, even before implementing a policy, drafting these sort of sample email communications to their employees about, hey, we're monitoring this. This is what we're going to do between now and a full policy rollout. Here's what you can do. Here's what resources there are, those types of things. So we're happy to talk to you about that. And of course, as she mentioned, we're developing sort of, template internal policies that we can kind of use as a starting place in our discussions with you about what your policy is going to look like. Because I think everybody's will be, have their own unique elements to them. So we're happy to discuss those with you. And then finally, just on a note about our upcoming seminars, we've got one actually this coming Thursday, which should be really interesting, about supporting veterans and reservists in the workplace. But our colleague, who is a veteran, Demetrius Pyburn, is going to be presenting and then on December 1st, an upcoming one on religious diversity in the workplace. And I'm sure there's going to be some potentially some talk about religious accommodations in the COVID era as well with that. So keep those on your radar. I think they should be very interesting. And there's the link to our blog on the slides as well if you need to go get that. Chris, have we addressed all of the questions in the Q&A, or do we have any outstanding?
The only one that's outstanding is one from Debbie Harden, which you and I can take offline, but do we recommend a local government have the policy by December 6th since they were not included?
Yeah. I have talked to a couple of local government clients about this, and I think that's probably an individual conversation to have. So we can take that one offline, but otherwise, thanks everybody for the great questions. I think it's probably helpful for everyone to see those questions and hear the answers to them, and for all those that made comments in the chat box as well. And thank you again for joining us. We'll try to keep you updated on these legal developments as they come out.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.